Good morning. Welcome to the latest in our series of DMH Stallard podcasts. Today we're going to be looking at the Employment Rights Bill. It's probably not an overstatement to say that this piece of legislation is probably the most important piece of legislation that we are likely to see regulating the employment relationship for the next decade. It's certainly the most important that we've probably seen in a generation. I'm very pleased to say that this morning I'm joined by my partners, Greg Burgess and Rebecca Thornley-Gibson. And between them, Greg and Rebecca are going to run through some of the key points and developments in the context of the Employment Rights Bill. We'll kick off first of all, if we can, Rebecca, on collective redundancy consultation. I wonder if you can just broadly set the scene for us in terms of what the initial draft of the legislation was saying, and then just highlight where we've got to with the latest changes.
Yes, hi Rustam. Yes, so originally the bill was proposing the removal of what we call the one establishment trigger. So if we take ourselves back to collective consultation, we know that if you're proposing to dismiss 20 or more employees in a 90-day period, then collective consultation is triggered, but it's only triggered if those numbers are at one establishment. So what the original Employment Rights Bill proposed was the removal of the one establishment test. So that would effectively mean that if there were, let's say, 10 redundancies at one site and another 10 at another site, overall, that would have triggered the collective consultation as proposed originally in the Employment Rights Bill. What has now been proposed is that we don't completely ditch that one establishment test. So we will keep the 20 or more redundancies at one establishment. But the amendments made in early March were that there would be a threshold number across all sites. So if there was a certain number or a certain percentage of employees where it was proposed they would be made redundant across all sites, that would also trigger the collective consultation. So that percentage, we don't know what it will be. If it was 10%, then that's 10% perhaps across all sites. Obviously, if there are still 20 or more redundancies at one establishment, that will still be triggered. But this introduction of a threshold number is going to create an added complexity probably to employers who are thinking, well, in January 2025, I made 15 redundancies at a particular site. I'm now making 6 at a completely different site, and maybe in a month's time, I'm making another 19 at another site. Now, those numbers together might hit the threshold number, of which we don't know what that threshold number is yet. It could be a number, it could be a percentage, more likely to be a percentage. So it's quite a significant change, which will require even more record keeping by employers. We've also had, I think it's also important to remember the protective award. So the protective award currently 90 days. If you don't comply with those collective consultation requirements, that protective award is going to increase to 180 days. So massive impact if you don't get it right.
Thanks. There's quite a lot in there, Rebecca. And as you say, when we're looking at collective redundancies, it's really important to run through the different steps. So the legislation is certainly going to have some impact. Greg, when we look then moving away perhaps from collective and towards individual dismissals, obviously probably the most high profile provision in the bill, I mean, most talked about is in the context of unfair dismissal. And it seems that there are various aspects to that. There's the service, there's probationary periods and limitation periods. Can you just run us through again, really, as Rebecca has done, what was the legislation as initially drafted, and then where are we up to now with the amendments?
Sure, no problem. Yeah, so for some years now, the qualifying period of employment for someone to bring an unfair dismissal complaint is 2 years, and has been 2 years. Cast my mind back probably 10 plus years. It was 1 year. It was 12 months. Where the headlines have been grabbed by the proposed changes is that the qualifying period will be removed. It will become a day one right to bring a claim for unfair dismissal. Now, what will happen going forward is that there will be more use of what's called the initial period of employment, probationary periods, to coin a phrase. So there will be provisions whereby that if a dismissal is made during a probationary period and it follows a specific process, then the rules in relation to unfair dismissal apply. Now, what we don't know is exactly what the process will be that the employers will have to follow. We do know that it will cover dismissals for conduct, performance, and probably some other substantial reason, but it probably won't cover redundancy dismissals. So when we had the update in March, we were waiting to find out what that length of initial period will be. The government has talked about possibly a 9-month probationary period, but it's all subject to consultation. It's going to be somewhere between 3 and 9 months. If I was a betting man, I'm guessing it's probably going to land at around 6 or 9 months. But we don't know yet, so we're still waiting for that information. We're still waiting for details about what the process will be that employers will have to follow to fairly dismiss. We don't know what the compensation might be for fair dismissals in that initial period. And in terms of limitation, there's also been a proposal that the employment tribunal time limits will be extended. Currently, most employment tribunal claims, unfair dismissal, discrimination, etc., must be brought within 3 months, either of the dismissal or of the act of discrimination. The proposal is that will be extended to 6 months. And that's quite a significant change, because that 3-month period is critical for someone to pursue their claim in the tribunal. And the rationale for extending it is that it can take time for individuals to take advice. It can take time for internal appeals to processed and concluded, and so it gives individuals more time to collect their thoughts, to take advice, to prepare their claim, and then to start the ACAS conciliation process. So we do see that extension being quite a significant change.
Thanks, Greg. And just to check, I don't think there's anything in the legislation which is talking about changing the ACAS conciliation process, because obviously effectively you get the best you can, depending on the dates, as an individual, get the best part of another month, can't you, in terms of extending the limitation period. I don't think there's anything in there changing that. So essentially it'll go from 3 months, possibly 4 months, to 6 months, possibly 7 months. Is that your understanding?
Yeah, no, exactly right. So there's no proposals to change the ACAS process. So from an employer's perspective, it will still be the same, is that once you get contacted by ACAS, you know that the individual is starting that tribunal process. Once the ACAS conciliation is concluded, you know that you may then get the claim form from the tribunal, because that's the point at which the individual can then issue their claim in the tribunal.
Great, thanks very much, Greg. We move on to guaranteed hours. Now, obviously, this is an area which impacts or will impact very heavily on certain sectors and on certain employers. Rebecca, I think that this is covering areas such as notification of shifts or shift cancellations and compensation and those sorts of things, but there's a lot in there from memory. Again, can you just help us at a high level unpack what we're looking at and what the change is in the latest draft of the legislation?
Sure, Russ. Yeah, absolutely, Rustam. I mean, I think, as Greg said, the unfair dismissal has probably been the headline grabber in some respects. I think guaranteed hours, 0 hours, low hours is going to be sort of the headline sort of grabber and the most complex part of this bill moving forwards. It started off complex. It's now horribly complex. I fear it's going to be unworkably complex by the time we get to the end of this. But essentially, there is going to be no ban on 0 hours contracts. You know, everybody sees the headlines, but there is no ban on 0 hours contracts. In fact, I think it's useful to remind people the only restriction on 0 hours contracts at the moment is the prohibition on exclusivity clauses in contracts. And that is it. That was introduced in 2015. And for 10 years, we've had nothing else other than, a lot of people complaining that they are exploitative. So what the Employment Rights Bill has done is they have said that if you are a 0 hours, if you're on a 0 hours contract, or if you're on a low hours contract, then you will have a right, if you're a qualifying worker, to guaranteed hours at the end of every reference period. Now, what that effectively means is that if you've done a certain number of actual hours in a reference period, which we think is going to be 12, and you're on a 0 hours contract, or you're on a low hours contract, we don't know what low hours is going to mean yet. Let's say it's 4, but we don't know it's 4. But if you're on a low hours contract, then you will have the right to be offered a new contract on guaranteed hours, and those guaranteed hours would be matching the hours that you had done in the previous reference period. So lots of things there to unpick, such as who's going to be a qualifying worker, what is going to be a low hours contract, what is the reference period going to be, what are the terms of the offer going to be, all sorts of things. So that's probably the main part. You then have the extra, protection in that you will have, as a 0 hours or low hours contract worker, the right to reasonable notice of your work schedule. You'll also have the right to reasonable notice in respect of any cancellation or curtailment of shifts. So that is really bringing about as much as I think employers can do in terms of predictability of work patterns. And people might remember that there was a piece of legislation that was due to come in last year around predictability of work patterns for 0 hours employees that's been shelved really because of this particular proposal in the Employment Rights Bill. And there's also going to be compensation for cancelled shifts or late notice. Now, the amends that were made on the 4th of March apply to the fact that agency workers are now going to also receive the same protection. And that's really to remove the concerns, and quite legitimate concerns, I think, that employers would potentially use agency workers to try and get round some of these proposals in terms of providing greater protection for 0 hours and low hours workers. Now, the responsibility when you get into the protection for agency workers is probably going to be quite complex as well. And may feel quite unfair. So hirers, so the sort of direct end user employers, are going to have responsibility for offering guaranteed hours contracts to agency workers. The responsibility for providing agency workers with reasonable notice of shifts is going to be a dual responsibility. I'm not sure how that's going to work. That's going to be the agency and the hirer. And the responsibility for compensating for any short notice or curtailment of shifts is going to lie with the agency, but they'll be able to recoup that in some situations from the hirer. So you can see all sorts of changes to the commercial contracts, the agency worker, commercial contracts between the hirer and the employer in those circumstances. So I think, sort of trying to unpack that in terms of impact, my take on that is that it's going to be so complex, you're just going to have less use of 0 hours contracts. Employers are going to say this is just too much, and they're going to try and find some other resourcing model, possibly move back to more fixed term, although query if you're moving to a fixed term contract and you're getting day one unfair dismissal rights, that's going to be a problem as well. But, there is going to be a huge admin burden on employers keeping track if they're using guaranteed, if they're using 0 hours or they're using low hours contract workers. So there's a lot to happen here, a lot of case law that's going to come on this, and a lot of uncertainty.
Rebecca, thank you for making, I think I agree with you, what's arguably the most complex piece relatively intelligible. Can I just follow up? Just as I was listening to you, I was sort of thinking, well, 0 hours and low hours, and I get that we're waiting to know what a low hours contract will be. What about annualized hours? Is there a direct reference in there to annualized hours? I'm just thinking that if it's a more seasonal type of environment and employment, will annualized hours be subject to this automatically to the same regulation, or is that a possible way through?
No, I don't think it will, because annualized hours, you're going to have a guarantee of a set number of hours over the course of the year, as opposed to your 0 hours is you haven't got a guarantee of any hours whatsoever. You could be provided with nothing. And then the low hours is likely to be probably, I would have thought lower than perhaps the number of hours that would normally be used in an annualized hours contract. However, there has been concern about seasonal workers and seasonal contracts who perhaps are doing work at Christmas. For example, somebody might start work, mid-November, and perhaps a little bit earlier than mid-November to get into their 12-week reference period. But they might start preparing for Christmas, and it's known that those hours are not going to be there after that Christmas peak. And that is a worry, and that is something that consultation is still taking place on. So yes, there is an issue there in terms of some seasonal workers, but perhaps the more traditional annualized hours that are used, where it's perhaps a more increased hours provision in the annualized contract. Hopefully, there won't be too much impact on those, but it depends on the amount of the annualized hours.
Thank you. And then just going on to another area, largely unconnected, although there is some, I guess, broad equivalence, statutory sick pay. I think there was some change in the original legislation, quite a fundamental change. Just again, help us with that, if you would.
Fortunately, this is a little bit more straightforward. So basically, there's going to be a day one right for employees rather than having to wait for statutory sick pay for their 4 days. There's going to be a removal of the lower earnings limit for qualification to get that statutory sick pay. And then the latest amendment on this has been that for those employees who are on less than the current lower earnings limit rate, which is currently £123 a week, they will be guaranteed 80% of their earnings. So their statutory sick pay will effectively be 80% of their earnings, so that they have some certainty as to what they're going to get from their day one sick pay rights.
So is the 80% an average of their earnings? I'm sure I've read somewhere, yeah, sorry, go on.
No, sorry, go on, Rustam. I'm not sure what your question was going to be.
Okay, 80% of, it really is live, 80% of their earnings, or 80% of their average earnings, or 80% of average earnings, full stop. That was the bit that I wasn't sure about. I don't know whether it's clear.
It's going to be 80% of their average earnings.
Wonderful, yes. Thank you. Well, I've got a good takeaway from today, so thank you. Then, Greg, if I could come back to you, if that's all right. So, just I think another sort of quite big area, and it can be an area of some controversy around protection for those employees, those obviously female employees who are pregnant or are new mums. In the context of dismissal or redundancies, what's going on there?
Okay, so for some time we've had protection for female employees who are either pregnant or returning from maternity leave in relation to their redundancy protection. So for some time it's been the case that if they are facing a redundancy during the protected period, they have the right to be offered suitable terms of employment. And that protected period was extended a couple of years ago, so it now runs from the start, the point at which they inform their employer that they're pregnant, to 18 months from their due date. So if there is redundancy at any point in that protected period, then they have that right to be offered suitable terms of employment. Now, the bill proposes extending that right to cover other dismissals, so not just redundancy situations, but it could be another sort of dismissal situation. And in those circumstances, then they will be protected. Query how long the protected period will be. So the current state of play is that we've got for 18 months post due date. For these other dismissals, the suggestion in the regulations is that protected period will be 6 months from their return to work. But that's still to be decided. In relation to further changes in this area, there is an extension of parental bereavement leave. So currently, that right to parental bereavement leave covers stillbirths, which are stillbirths running from the 24th week pregnancy. The proposal in the regulations is to extend that to miscarriages, which are losses of the child before 24 weeks. So we can see that the parental bereavement leave will be extended to miscarriages as well as stillbirths. But that is, broadly speaking, the changes in relation to female employees on maternity.
So, Greg, sorry, just clarifying, how long is the length of bereavement leave currently?
Yeah, so it's 2 weeks is the period of bereavement leave.
And there's nothing in the draft legislation that's suggesting an extension of that period, at least at the moment.
There's not, no.
No. Okay, fabulous. Thank you very much. So, Rebecca, fire and rehire, that's another of the areas, obviously, that's had quite a lot of profile and column inches in Old Money written about it. What are we looking at in the context of the draft legislation in relation to that area?
Yeah, so we're really looking at strengthening some non-statutory provisions that were introduced last July, where we had the Code of Practice on Dismissal and Re-engagement that was introduced to put in place certain procedures if there was going to be a potential dismissal and re-engage. The usual situation being the one whereby an employer wants to change contractual terms and the employee doesn't agree to that. What options does the employer have? The usual option is they can dismiss and re-engage by offering the new terms under a new contract. We tend to call it, I think the lawyers call it the nuclear option. We try and say to clients, don't do it, please don't do it, try and get the consultation, but you can't always get employees to agree. So there have been situations where dismissal and re-engage has happened and it's worked. There's also been situations where dismissal and re-engage has been a disaster, such as the P&O Ferries case a couple of years ago. So the Employment Rights Bill, in terms of strengthening that dismissal and re-engage or fire and rehire option that employers may have, what they're looking to do there is both updating the code of practice, so there'll be an updated code of practice, but also to make it automatically unfair, so an automatically unfair dismissal, where the dismissal is the reason for employees not agreeing to the new terms, or because the employer intends to employ someone else on those varied terms. So in some respects, employers might think, well, this means we can never change contracts if employees don't agree. And that, I think, is the worry about how restrictive this automatically unfair dismissal protection could be on employers' ability to change terms and conditions. The only exclusion that is being mooted, well, that is being tabled at the moment, for changing terms and conditions without the consent and therefore allowing the dismissal and re-engagement under new terms, is when the business is in financial distress. So that's quite limiting. And I think it is quite worrying that there does seem to be such protection. Automatically unfair dismissal will not require any qualifying length of service. I know we're going to obviously have the unfair dismissal day one rights coming in probably 2026, I think. But if this comes in before, this will be automatically unfair dismissal day one right straight away. So I think, this is another one where there is quite an impact on employers of how they want to change terms and conditions.
Thanks, Rebecca. Yeah, I mean, just again, listening to what you were saying there, I think one can understand, and I don't think it's just P&O, but I think the P&O case was probably one which has really given some, as it were, some impetus to this. One can understand the situation where you say it's automatically unfair simply to say, well, I've dismissed you because I'm employing somebody else on other terms, because the existing employee, one might say, should at least get the first opportunity or first right of refusal, or however you want to put it, whereas that wasn't, as I understood it, what happened in the P&O case. But it's that other piece, isn't it, to say that simply refusing to accept varied terms and conditions is an automatically unfair dismissal without looking at what's the relative. I mean, it is a tricky area at the moment where you're balancing the interests of employer and employee, and what's the impact on the employee, and what's it so I absolutely agree that is tricky. I read something about fire and rehire in the context of interim relief and the change there. Was that?
Yes. So what was originally proposed in the bill was that there would be interim relief available for employees who had been dismissed, so they could go off to the tribunal and they could get their early tribunal sort of determination effectively be reinstated with the interim relief. That has gone now, so there is going to be no interim relief for employees interim relief applications for employees who have been dismissed in breach of the fire and rehire proposals.
So, I mean, again, that almost feels a bit counterintuitive, because interim relief, I think, first came, didn't it, with certain trade union related activities, where you were saying, look, this is as a way of trying to, as it were, maintain the employment and almost the status quo. And then that's been extended, I think, to whistleblowing claims. One could see the argument, if the objective is to ensure that the employee remains in employment, that one could see the argument saying keeping interim relief. So instead what we've got, I think, is a net effect that the employee has a strong right to claim unfair dismissal, but essentially that's really going to end up being a claim in damages.
It is, and I think the sort of the removal of the interim relief option, and also the interim relief option was there originally for the collective redundancy, and that's been removed as well. But because you have the protective awards for the breaches of the collective redundancy and the fire and rehire, and because those have been increased from 90 to 180 days, and in addition, on the fire and rehire, if you don't comply with the code of practice, you have the 25% increase on the protective award. You could have a protective award of 180 days plus 45 when you take your 25% in. That's probably punitive enough for employers.
But I guess it just seems counterintuitive if the objective is obviously to keep people in employment, rather than simply to say you get some cash after, I don't know, 2 years, 3 years after tribunal litigation nowadays.
Yeah, I mean, I think my view on this is that fire and rehire is probably going to involve quite a lot of employees. Collective redundancy is going to involve a lot of employees. If everyone's got to be if everyone was going to then be subject to interim relief, that burden on the employer would be immense financially if they had to allow those interim, relief applications until the determination of, the main hearing as to whether they had or they hadn't breached the legislation. So I think that was just a step too far.
Thanks, Rebecca. Greg, we've got a couple of other areas. We've got the Fair Work Agency. Maybe you can just outline something on that for us in a moment. And also, I think there are some other provisions that it's right just to flag in relation to collective organisations, so sort of trade unions. So first of all, the Fair Work Agency. Can you just give us a summary on what we're looking at there, please?
Yeah, sure. So you just mentioned or touched on 2 to 3 years for a tribunal claim to take its course. Yes, currently the environment is still that the employment tribunal system is under a lot of strain and stress, and we're experiencing significant delays in the system, albeit that they are desperately trying to recruit more employment judges to relieve the pressure. Now, one thing the government is proposing to help relieve the pressure is to bring in a new enforcement agency called the Fair Work Agency, and they'll be responsible for enforcing certain types of legislation, certain types of claims. So what's on their list of things to deal with will be national minimum wage. So that's currently enforced through HMRC, and that will be dealt with by the Fair Work Agency. Compliance with employment agency legislation will be their responsibility, as will SSP and holiday pay compliance. They will be responsible for the gangmasters legislation, which is quite a niche area of law, but one which does come into play occasionally, and also to ensure that there is proper compliance with obligations under the modern slavery legislation. So they'll be responsible for making sure that employers are complying with their obligations in relation to those areas. Now, earlier this month, in the latest proposals and the revisions, we had a little bit more detail. So what we know now is that if employers fail to keep adequate records of holiday leave and holiday pay, which was probably going to be 6 years worth of records, that if they fail to do that, then they could face unlimited fines. It would be a criminal offence with potential for unlimited fines. Most employers, in my experience, have 6 years worth of records of these things, but some may not have everything, and the same applies in relation to SSP records. You need to make sure that you have your records in place for that 6 year period. The implications if they do not keep those holiday pay and SSP records is that you could face a notice of underpayment from the Fair Work Agency, and the penalties are up to 200% of the sum underpaid. And the way they are setting up this agency is that they are hoping it will be self-funding effectively, so the monies they collect from underpayments will fund their enforcement work. And in relation to the enforcement itself, what's quite interesting is that they will have the power to bring a claim on behalf of an individual, so they can enforce on behalf of the individual, even if the individual doesn't actually pursue the claim themselves. And also, they will have the power and the ability to provide legal assistance to the individual. So if the individual is prepared to bring the claim but doesn't have the funds to pay for solicitors to help them, then they can provide that legal assistance. So you can see the environment that getting into is to make sure that the enforcement is taking place, so then it funds their continued work. So that's the Fair Work Agency. You just mentioned trade union and what's happening in relation to trade union rights. At a high level, I won't go into all of the detail, but at a high level, the government's absolutely committed to strengthening collective bargaining rights, and they believe it's key to tackling problems of job insecurity, discrimination, low pay, etc. So they're bringing in various new rights to strengthen trade union protection. That includes an extended right of access for unions to access the workforce to try and recruit members. they are proposing that the Section 1 obligation on employers, so Section 1 is certain things that must be in every single employment contract. They are proposing adding that the employer makes clear that the employees have the right to join a trade union. That's a slight extension to the existing Section 1 obligation. And they're also making some changes in relation to the rules for balloting for strike action and what level of support there needs to be within the bargaining unit. The whole direction of travel is to make it less cumbersome for trade unions to successfully ballot for strike action. And also they're proposing an extension of the mandate for that strike action. So currently, if a trade union successfully ballots for strike action, the strike action must start within 6 months of that ballot. Under the changes proposed in the last few weeks, that mandate period is extended to 12 months. So as long as a strike action starts within 12 months of the ballot, then it's protected industrial action.
Great. Thank you very much, Greg. Yes, it's quite a bit in there, even in relation to trade unions, as you say, and trade union collective action. Just now, I guess, drawing things to a close and looking ahead and some of the things that aren't in the bill. Well, one of the things that I saw that the government is saying it won't try and proceed with is the so-called right to disconnect. In other words, employees being able to say, right, well, that's it. I've done my hours, I've done my time, and don't expect to be able to contact me. That's been a controversial right in a number of parts of the world, but it was said it was going to be introduced here, but the government said they're not proceeding with that. Couple of things, one maybe from each of you of areas where we think the government is still likely to legislate in due course in this parliamentary term. Ladies first, Rebecca.
Right, well, sort of, I was going to say it's one of my favourite areas. I'm not quite sure why it's my favourite, but I find it fascinating that we have probably about every 5-6 years a new consultation on whether there should be a simplification of worker status. So we've currently got employees, workers and self-employed, and over the years we've had various reviews into, well, that's not very good, is it? And should we do something else? And then we've had outcomes but no implementation. If there's ever going to be a government that's going to try and actually finish the job, it would be, I think, this Labour government on the back of the Employment Rights Bill. So that's effectively, are we going to scrap the separate employee and worker categories and probably just have worker? The rights that are now being given to workers as well as employees, I think, are increasing. You've got things such as the 0 hours sort of workers. If they're going to be given guaranteed hours and there's going to be, sort of greater perhaps obligations on both parties there, is it going to make a lot of people who are 0 hours workers on low hours casual contracts, are they actually going to morph into employees over time with these new rights that they're getting? So that's going to create a complication anyway. So we may finally have, a potential outcome to worker status. The problem is the complication of the tax regime, having different employee and sort of self-employed tests. So we're probably a good 3, 4, 5 years even away from it happening. But I think it's something that the Labour government will try and do again. So, simplify worker status and give us just a worker as opposed to employee and workers.
Thanks, Rebecca. I think that's an interesting one. Greg, how about you? Anything that you have picked up that you think will move ahead?
Yeah, very recently, so the 20th of March this year, there was proposed announcement in relation to pay gap reporting. Well, for some years now, we've had gender pay gap reporting as an obligation for larger employers. Last July, the government had announced that they would bring forward obligations to report on ethnicity and disability pay gaps, so as well as gender pay gaps. Last week, so 20th of March, they launched a consultation on proposals to implement this, and the consultation closes on the 10th of June of this year. What will it mean? It will probably mean that larger employers, so over 250 employees, will have to report. Exactly how it's going to work for ethnicity remains to be seen. This is subject to consultation. The proposal is that there should be at least 10 employees in an ethnic group for the obligation to report to be triggered. And then in relation to disability, the proposed approach is to have a binary approach on reporting. So you will have your two groups, which are disabled employees and non-disabled employees, and you'll have to do pay gap reporting in relation to those two groups. That's all we know so far. As I say, it's open to consultation currently. When we talk about disability, it always throws up the question of to what extent do employers know of people's particular disabilities. So we'll see how this plays out over the coming months. The consultation, as I say, will close in June. We'll then probably get some draft regulations, but it probably won't be coming into force, I wouldn't have thought, until sometime next year.
Wonderful. As you say, Greg, there's so much in there. I mean, will it become mandatory to declare one's ethnicity? It's never been historically, even for the purposes of monitoring. So it's going to be, and as you say, similar issues around disability. Obviously, we haven't had a national registered disabled scheme for very, very many years. So very interesting to see how that plays out. Well, that brings us in any event to an end. I'm very grateful to both Rebecca and Greg for doing all the hard work in terms of going through the various areas and proposed changes. I hope you've found that interesting listening. Obviously, any questions, points arising, please do get in touch, and we will be back soon. Thanks very much. Bye-bye.